Welcome to Popcorn Planet. I am Andy Signore, and I'm sorry we're starting this late, but I wanted to get into this. I saw that the Gabby Petito family is fighting against Brian Laundrie's family in a court of law. We are currently live. Sorry we didn't start this a little earlier, but better late than never, because I want to watch how the Petitos fight for this appeal. Guys, if you remember the Gabby Petito case, she never really got justice. The Laundrie family did so much in our opinion, and they are currently trying to stop them from getting this jury trial this summer. I'm here with Kim. Welcome back, Kim.
Hello.
We're a little late, but I thought this is too important. We covered so much of this Gabby case, and I want to see what happens. And before we get the verdict, which we'll get a little bit from this judge, I'm starting now from where Gabby's family's attorney just stepped up. Let's watch this together.
Your Honor, this case is not simply about the silence of Christopher and Roberta Laundrie, who knew that their son had brutally murdered Gabby Petito. It's not simply about their callous refusal, despite pleas from the Petito family, to speak up about whether or not Gabby was alive and if she wasn't, where her body was located. It's about a course of conduct that they committed from the moment they learned on August 28th of 2021 that their son had brutally murdered Gabby Petito up until the time that her body was found. And as this court has already noted and pointed out, that includes the statement that was made the one time they decided to speak up. They spoke up through their attorney, and I'll touch upon the importance of that in a little bit. As the court knows, you're bound to accept as true all of the facts alleged in the four corners of the complaint. And I'd just like to review what some of those allegations are.
Well, let me ask you this, Mr. Riley. And let's lay aside the statement that the attorney made on behalf of the Laundries. What duty did the Laundries have to do anything to help Mr. Petito and Ms. Schmidt?
That's a fair question, Your Honor, and I've struggled with the answer to that particular question, and I guess maybe by answering this I'm deflecting, but my answer is this. It's about what they did with the information that they have, not just not disclosing what they knew to the Laundries. And by the way, they could have, to the Petito family, excuse me, they could have made an anonymous phone call and said where the body was located, and that would have helped this situation tremendously. They knew, starting on August 28th of 2021, that Gabby was dead. They knew where Gabby's body was. They knew that the Petito family was desperately searching for information, but they did things affirmatively. They didn't just remain silent. Brian Laundrie came home in Gabby Petito's van by himself to his family's home. That family, knowing that Gabby was dead, knowing their son had murdered her, knowing where the body was, and in particular, knowing that Joseph Petito and Nicole Schmidt were desperate to learn where their daughter was located, they went on vacation. They assumed and continued their normal life as though nothing had happened, while this family was suffering, wanting to know what where their daughter was.
And
Not
Gabby
only
lived
did
with
she
them.
Let's get back, though, to
Gabby
legal
was their
duty.
daughter too, in a way.
She
should have
hear
been.
what you're saying, that these facts might sound bad, but you know, we're not talking about social mores here. We're talking about legal duty.
We're talking.
So let's try to focus in on what duty did the Laundries have? What did they owe to Gabby's parents?
Well, let's put in perspective what the relationship was, Your Honor. These people were not strangers. These people were, their son was engaged to marry Gabby Petito. Gabby had lived with them for about a year. They had both visited Joseph Petito's home and Nicole Schmidt's home. They were cordial. They had a cordial relationship, a warm and friendly relationship. They knew how much Gabby meant to Joe and to Nicole. Going to the issue of a duty, Your Honor, I struggle with that. I admittedly, it's difficult to say what it is, and that's why I'm saying there was a course of conduct that they did that was outrageous, culminating, in my view, in the statement that was made by their attorney, who, as Your Honor pointed out, is their agent. And what that attorney said in particular is telling. So there's no question that he represented, that he was making that statement on behalf of the Laundries, because he says it is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming on behalf of the Laundrie family. It
Yeah,
is our
couldn't be
hope
more
that the
clear than
search
that.
for Miss Petito is successful
That's
and
worse
that Miss
than Waldman's
Petito is
statements.
reunited with her family. That statement was issued with the full knowledge and consent of the Laundries, with the full knowledge on the part of the Laundries that Gabby was not alive and that Gabby's body was located somewhere out west. And instead, they make a statement saying, we hope you find her. We hope you're reunited, giving them false hope that perhaps their daughter is still alive. If that's not outrageous,
disgusting.
Your Honor, I don't know what is outrageous.
It's outrageous.
So I think when you talk about their affirmative duty to speak up, I struggle with that. But they did speak up. And when they
Yep.
spoke up,
They
they
lied.
made that very callous, that very terrible statement, giving hope to Joe and Nicole that perhaps
And wasting resources.
Gabby was still alive
Yeah.
with full
On
knowledge
a federal
that
level
she
as
was
well.
not. And Judge, when I talk about the course of conduct, I want to talk about some of the cases that I cited in my response to the motion where the court found that there was outrageous conduct. And I don't see how any of these cases are by any stretch of the imagination, worse than what happened in this particular case. In the McAlpin versus Sokole case, a patient went to a hospital to have an x-ray done. She put on a hospital gown. She walked into the x-ray room, and the minute she walked into the room, the doctor began berating her in front of other staff because she
That's
hadn't paid another
Rose,
doctor's
Gabby's friend,
bill.
by the way, for people who don't
He
know.
told her
this.
he wasn't going to treat her, and he told her that he was going to call security and have her removed from the hospital. That, according to the court, was outrageous. In Nims versus Harrison, a teacher, two students of the teacher wrote, published, and circulated a newsletter in which they had an article called Low Life, and they referred to that teacher in offensive language, threatened to kill her, threatened to rape her children, and threatened to rape their cousins. Outrageous. Ford Motor Credit Company versus Sheehan. Collection agent is unable to locate the debtor, contacts the debtor's mother, tells the debtor's mother that she's from a hospital out in California. She's trying to locate the debtor because two of the debtor's children have been in a serious car accident, and she wants to find the debtor so that she can let him know about this accident. The son speaks to the mother later that day, hears the story from the mother, spends the next 7 hours calling hospitals and police departments out in California, only to find out that this story was false. That was outrageous. The Dependable Life Insurance Company versus Harris case was talked about previously. In Liberty Mutual versus Stedman, the company delayed authorizing a lung transplant even though a judge of compensation claims had already ordered that they pay for the lung transplant. The carrier knew she would die without the lung transplant, so hoping the problem would go away, they denied payment in an effort to intentionally induce stress on her part to speed up her demise. The court said, under the totality of the circumstances, it's outrageous. Williams versus Mineola, and it's these two last cases that I'm going to cite the court to that I think are most instructive here.
We'll update you guys on what's happening
Williams
when they're
versus
done, so
Mineola.
just bear with us.
Police officers attended the autopsy of a teenage boy who had been murdered or committed suicide, and they were there with a videotape, a video camera, and a camera to record it because of the suspicion that a crime may have been committed. They took that video, they took those photos, and they took them to a party. And at the party, they shared them with other persons, including other police officers from surrounding jurisdictions, and they laughed and they joked about what was in those photographs. The court found that to be outrageous, and here's what the court said. As for what is outrageous or reckless or what is not, we emphasize that our society, as reflected, for example, in decisions of the courts of Florida cited earlier in this opinion, shows a particular solicitude for the emotional vulnerability of survivors regarding improper behavior toward the dead body of a loved one, and the special deference paid by courts to families' feelings where rights involving dead bodies are concerned is central to our decision. This area is unique, and once it has entered, behavior which in other circumstances might be merely insulting, frivolous, or careless becomes indecent, outrageous, and intolerable. One obvious reason is that the bereaved are already suffering psychic trauma because of the loss of the loved one, and are especially sensitized to any disrespect or indignity directed at the deceased body or a representation of it. The potential for severe emotional distress is enormously increased in that situation. All of this is well known to the ordinary person, and so a level of carelessness or callousness, which might not be considered tortious in other situations, can show outrageousness and recklessness when a dead body or a picture of a dead body is involved.
Well, Mr. Riley, how is a statement, "We hope this search is successful," how is that in itself outrageous?
It's a lie. It's said with knowledge that there's no hope of finding her alive because she's dead. It's said with an intention to give false hope to a family that their daughter may be alive. That's
and
outrageous.
to throw off an investigation.
Yeah.
And at this particular point in time, they had been begging the Laundries to tell them where their daughter was, and this is the statement that they issued the one time they chose to speak up. This was the statement that they issued, a lie that gave false hope to Gabby's parents that perhaps she might be alive.
That's what this case is about, just so you guys are following.
The other case, Your Honor, that I think is instructive is the
And
Thomas
a lot of lawyers
versus
don't think they're
Hospital
going to get
Board
it.
Directors case, and I think this one may be even more instructive. In that case, during I believe it was a hip transplant surgery, the decedent died. She died of cardiac arrest. What she really died, the real reason she died of cardiac arrest is because she was given an overdose of a particular medication during the surgery. And the doctors and the nurses agreed that they would not report the true reason for why she died. They would say that it resulted from complications of surgery. As a result, the complete autopsy was not done. The body was released to the family, and less than a week later, as the decedent's daughter was trying to bury her mother, she received a telephone call from the medical examiner saying, "You need to bring that body back immediately. We have to perform a complete autopsy." Again, the court said that was outrageous, and what the court said was, "We believe that the appellee's conduct in making false statements," and isn't that what Mr. Bertolino did on behalf of the Laundries here? "We believe that the appellee's conduct in making false statements which led to the interruption of Mildred Thomas's funeral and the return of her body for a second, more thorough autopsy rises to the level of atrocious and utterly intolerable behavior which cannot be condoned in a civilized society."
Yes.
As noted in Stedman, when an actor has knowledge that the other person is peculiarly susceptible to emotional distress, and the Laundries knew that because this family publicly said they were distressed trying to find their daughter,
Yep.
Yes.
the actor's conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge. We believe that in a situation where a person's loved one has died, it would be apparent to anyone that the person would be susceptible to emotional distress, and therefore that the action of providing false information concerning the loved one's cause of death meets the standard for a claim of outrage. In this case, they provided false information, a false impression, knowing that Gabby was dead, that she was still alive and she could be found by the family if they were searching in the right place. So I also think under the restatement of Tort Section 46, comment F says, "The extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity. The conduct may become heartless, flagrant, and outrageous when the action proceeds in the face of such knowledge, where it would not be so if he did not know." And that's basically what the Williams court was saying, and that's what I'm saying in this instance. The Laundries knew of the fragile emotional state of Joseph Petito and Nicole Schmidt at the time that that statement was issued. They knew that she was not alive. They knew that the family was hoping to find her. And they put out a statement as though they were supporting them, saying, "We too, we know she was our son's fiance, and we hope that you find that body too, or you find her and the family is reunited." Excuse me. That's callous. It's shameful, and it's outrageous. And by the way,
Yes.
This is a 2016 case. 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 The only reason that Mr. Bertolino is not a defendant in this action is because he's not a citizen of the state of Florida. I think there's also support for our position under comment E to the restatement, which says unequal position of the parties in a relationship where one asserts and has the powers to affect the interest of the other may also supply the heightened degree of outrageousness required for a claim of intentional infliction of emotional distress. Here, the defendants clearly had the power to affect the interests of the plaintiff because they could have told them where her body was located.
Yep.
And they chose not to do so.
And don't forget,
Yep.
they found the body like that when they finally got a chance to go look.
Your Honor, I don't think there's any question. There's been
For Brian's body,
nothing raised,
they
at
knew
least by
both Brian
counsel
and
in his
Gabby.
argument that
They were hiding
the
so
conduct
much.
didn't cause severe emotional distress to my clients, to the extent that they would suggest and have suggested, well, they were already distressed anyway, so all we did was increase their harm. I guess it's okay to kick someone when they're down, according to the Laundries. But going back to those two cases that I cited earlier involving dead bodies, the parties were already grieving, and it was the conduct after death that the court found was outrageous and permitted the case to move forward. So I think we have the issue of their conduct was intended to harm, or certainly what they did, they should have known was likely to cause severe emotional distress to my clients. We clearly have an outrageous conduct on their part. I think we have established that the conduct caused more emotional distress. It doesn't have to be the only cause of their distress. If it increases, that's sufficient to recover. And I don't think they're contesting at all that the emotional distress was severe. So I'll move on to the suggestion that the defendants get to raise affirmative defenses at this point in time.
Well, and thank you for doing that, because my question there is, I mean, the rule is that I can address it if it is apparent within the four corners, and effectively you alleged conduct which arguably could be considered criminal on behalf of the defendants. So why can't I consider the Laundrie's constitutional right to remain silent and other constitutional rights within the context of ruling on this motion to dismiss?
Well, Judge, I'm curious to find out what conduct
frustrating
it is
but
that the
fair
complaint
point.
says the Laundries committed that was potentially criminal. So if the answer is they were harboring a fugitive, there were no charge. Again, we're outside the record, but to my knowledge, or outside the four corners of the complaint, but the complaint doesn't allege that there were any charges pending against Brian Laundrie at the time. So they couldn't have been harboring a fugitive. Are they?
I'm not sure the absence of charges is the criteria that we use.
Well, Judge, what this is forcing me to do to address that is to go outside the record, which is not what we're supposed to do, to say he wasn't running. According to everything we know, the police knew where he was. So he wasn't a fugitive, so they weren't harboring a fugitive. I don't know what were the accessories after the fact. I don't know. Is there something they want to confess to? I'm happy to hear it, but I don't know that anywhere within the four corners of the complaint there's a suggestion that the Laundries were under investigation for a crime or that they had committed a crime. So, first of all, I think we shouldn't even be considering this as an affirmative defense. Secondly, you can't look at the complaint and determine was there an investigation into them and what were the crimes. So I don't think the Fifth Amendment applies. If we turn to the First Amendment, I will tell you I strongly disagree with counsel's assertion that it applies in all instances. The defendants rely on Woolley versus Maynard for the proposition that they have a constitutional right to say nothing. But Woolley says that the right of freedom of thought protected by the First Amendment against state action includes both the right to speak freely and the right to refrain from speaking at all. And we're not talking about state action in this case. The defendant says we're asking the court to force the defendants essentially to say something. That's not what we're doing. We're seeking damages for their conduct. More importantly, the First Amendment does...
Mr. Riley, though, I want to direct you back to paragraph 30 of your complaint, where you say that the defendants were keeping the whereabouts of Brian Laundrie secret, and it is believed were making arrangements for him to leave the country. So that's something that the plaintiffs themselves injected into the case. So that's the basis of my question, is now that you've put that fact into the four corners of the complaint, isn't that the basis for me to consider, without having to need a affirmative defense filed, if you will, the constitutional rights of the Laundries?
Judge, what's the crime committed there? What's the crime that if they are making efforts to try to remove him from the country? He's not been charged with anything. He's not a fugitive. There's not, that itself does not suggest that they were committing a crime. There has to be an underlying basis. If the complaint said there was a warrant out for Brian Laundrie's arrest and the Laundries were moving money around to try to move him out of the country, I agree with you wholeheartedly that you could arguably consider a Fifth Amendment argument in this case. But there's nothing in there to indicate that there was any criminal conduct on the part of the defendant. There's a statement that says they were moving money around to try to get him out of the country. Is that unlawful as it's pled in this complaint? No. It's not.
Okay.
Going back to the First Amendment issue, Your Honor, it doesn't set forth an all-encompassing right to remain silent. Only where through state action they are being asked to espouse a religious, political, or ideological cause which they do not support do they have that right. And I will cite to you from one of the cases in my brief, my motion, the Overbay case, which says, freedom of speech includes both the right to speak freely and the right to refrain from speaking at all. At its heart, the right to refrain from speaking is concern for preventing government from compelling individuals to mouth support for views they find objectionable, or mandating speech that a speaker would not otherwise make. In other words, the court continued, the right to refrain from speaking limits the government's ability to sanction or override a private individual's preference for not making certain speech. Not all speech, certain speech. So let's look at Overbay.
Mr. Riley, you have 5 minutes left, sir.
Thank you, Your Honor. Are the Laundries suggesting that we're seeking to compel them to mouth support for a view they find objectionable? Do they find it objectionable to tell a grieving family where their daughter's body is located and that she's no longer alive? Do they believe that they would have a personal individual preference for not making a statement that they knew where the body was located? That's ludicrous. The First Amendment does not apply in this particular circumstance. We pointed out that they contacted counsel to show a course of conduct and to support our proposition that they knew that Gabby was dead and that they knew where her body was located as of August 28th. They immediately contacted an attorney.
I get back to where's the duty, and certainly there's no legal prohibition on calling a lawyer.
I'm not, Judge, I'm not going there. I'm not suggesting, I'm saying that's support for our position that they knew. That's circumstantial evidence, in my view, that's why it's in the complaint, goes to show that at that point in time they knew. I'm not being critical of them retaining an attorney. I'm not suggesting they shouldn't have. I like the fact that they retained Attorney Bertolini, and Attorney Bertolini said what he said on September 14th of 2021. So we're not saying they shouldn't have hired an attorney. We're not saying hold it against them for hiring an attorney. I'm simply saying they hired one immediately after getting a phone call from their son, who then returned home without Gabby. Circumstantial evidence to show that they knew. That's the only reason that I raised that issue about them hiring a lawyer. Your Honor, unless you have any other questions, I believe I've covered everything I wanted to cover.
Thank you very much.
Thank you.
Mr. Luca, I'll give you 2 minutes for any brief reply, but let's keep it to 2 minutes.
Yes, thank you, Your Honor. Your Honor, one thing I would point you to with regard to that City of Mineola case, Your Honor, there is a second DCA case, Crenshaw versus Sarasota County Public Hospital Board. I think it's cited in both my motion and the plaintiff's brief. And in that case, Your Honor, that case also involved a dead body, a stillborn child. And basically what happened is after the child was born, deceased, somebody within the hospital mutilated the child. It ended up going down a laundry chute. And in that case, Your Honor, importantly, the court noted that obviously if the mother had witnessed all of those terrible things that happened to the child, that might be one thing. But the court noted that the physically injured party should be directly involved in the event causing the original injury. If such a person sees it, hears it, or arrives on the scene while the injured party is still there, then that person is likely involved. And then they go on to say, here, appellant did not allege that she saw the mutilated body or that she was involved in the event, except for the birth of the stillborn child in any way. So, and Your Honor, that Stedman case was cited in Mineola, and in Mineola, the fifth DCA said that to the extent that Stedman conflicts, they're not going to follow Stedman. But Stedman would control here because it is a second DCA case. And lastly, Your Honor,
I love how joint the parents
I
are.
didn't raise this, get time to raise this initially, but I would point Your Honor to
such a strong united front together. It's
another
I love
important
it.
case, which is MM versus MPS. It's a third DCA case from 1989, again cited in the papers. And although not perfectly analogous, that case is instructive because it involves the parents suing the defendant for something that was done to their daughter. And in that case, the defendant told the parents that he had sexually abused their daughter, but obviously the parents were not present for the abuse. In that case, the court found that the appellants were not present when the alleged mistreatment of their daughter took place and may not claim emotional distress for her injurious or offensive treatment. Now, the plaintiffs countered that the disclosure of the treatment of their daughter was what caused their emotional distress. And the court said, after reviewing the law, we are unable to conclude that learning the awful truth from the defendant afforded appellants grounds for recovery for their own distress. And the court said, if courts were to allow relatives of tort victims compensation for the distress they suffer when they receive bad news about family members, when there is no attendant intentional or reckless conduct directed toward them, an avalanche of litigation would ensue. Compensation is available for actual harm to the victim. Only in carefully prescribed circumstances is compensation permitted for relatives who suffer emotional distress. It is not lack of compassion, but necessity that restricts relief to the immediate victim. And Your Honor, in this case, I would just submit to Your Honor that allowing a cause of action like this to proceed would create an avalanche of litigation that the tort was never intended to cover. Thank you, Your Honor.
Thank you both for your arguments. I will do my best to get a written order out within 2 weeks of today. Anything else in this first case before we recess the first case?
No, Your Honor. No, thank you, Your Honor. May I be excused?
Yes, sir.
I don't represent any parties in the second case, so.
That's fine. While Mr. Luca is cleaning up, is there anybody that's going to be here in the second case, which is Nicole Schmidt as administrator of the estate of Gabrielle Verona Petito versus Barry F. Spivey as curator of the estate of Brian Laundrie, case number 2022 CA 2115SC.
I don't even know what the second estate is, but all I know is
Your Honor,
that we have 2 weeks now
on behalf
for a
of
written statement.
Nicole Schmidt as personal representative of the estate of Gabrielle Petito.
So they're fighting over the
And
estate.
has anyone
Yeah.
appeared for the respondent?
No one, to my knowledge, has appeared. As Your Honor knows, Attorney Spivey, there was an order entered at the request of Attorney Spivey.
All right. I mean, what the state stuff is less intriguing to me, more about the what we just saw. All right. So I brought in Linda. I brought in Steph is here. What's up, guys?
Hey,
I was sorry we were a little late and didn't get the beginning of this, but just for a quick update, and then I want to have Linda and Kim offer their insight. Plus, they did mention the Johnny Depp trial, which I'm trying to find the clip for because it's all happening as we were there. But the other thing I want to be able to share quickly, which I just haven't done in a long time, and I'm so excited to do it, is to share a Brian Enton tweet. Because all those viewers, you remember how much we love Brian, and as we covered this case, it was great. But there we get to check in his feed. Judge says focus on legal duty. What duty did Laundries have? What did they owe Gabby's parents? Petito attorney says their families were not strangers. They'd visit each other's home, and Gabby and Brian were engaged to be married. Much of this comes down to the statement during the search by Laundrie attorney Stephen Berlino. We hope the search is successful. Petito attorney says that lie gave us false hope. So they got to sort of prove, like, did they do something detrimental, egregiously with malice to, cause this is really what they have to do. What's the crime is really what comes down to. And so it's a very interesting case because I know a lot of you guys who followed the Gabby Petito case and want justice. It's like a no-brainer. I even see the poll. 86% of you want to see this go to trial, but are they actually responsible? Are they despicable? Yes, in my opinion, they're despicable. That's not what's up for debate here. It's about legally, are they allowed to be taken to trial? Arguments are finished. It'll take 2 weeks for this written trial. So we will update you as it happens. But it's nice to see the family there united. It's nice to see them. I mean, it's such a tragic case no matter what. But I want them. I want the best for them. I want to help in whatever they need because what they went through was just so tragic. The loss of Gabby was something that affected us all. And it was such a crazy case that all could have been stopped if the Laundries just spoke up. And so that's really what this is about. And so it'll be interesting to see if this goes through. And I hope it does for the sake of the Petitos to get some justice on behalf of their daughter. But I want to go to Kim and sorry, Steph, you have a question?
No question, more just of an observation. Towards the end, I think it's going to be troubling for the Petitos because the Laundrie side was referencing precedent in other cases, kind of in a similar situation where they're turning around and saying, you got these cases where, the parents knew what had happened to the daughter or the son or essentially the victim, right? But when it tried to go to trial, when it tried to go to a civil case or whatever, it got thrown out because the responsibility wasn't on them to say anything, even though they knew. They had that right to not speak up at all, basically. And he was referencing a couple of precedents, a couple of cases, from my kind of understanding of it, in regards to similar situations like this and how the legal system have ruled on it. So I hope it goes through and I hope it does proceed to trial. But referencing those precedents and the kind of questions that the judge was asking the Petito lawyer, do you know what? I've just got this sad, sinking instinct feeling this ain't going to trial. It's not. Because if it did and the Laundries got prosecuted and the Petito family won, that's actually going to set a new precedent when all precedents have already been set in this kind of scenario in the first place. So, I hate to have to say this out loud, but I don't think it's looking good for them.
No, I mean, I've heard this from other attorneys, and I didn't realize this was happening, and this will be sort of a long process. If they are granted this, then they will get a trial, and it'll be next year. So it's not even something that's going to happen quickly by any stretch of the imagination. This will be a long process. But we will cover and keep it updated because this is an important one. But yes, this is an uphill battle. And Arlie, thank you so much for the comments. You have the right not to self-incriminate. That there's no duty to speak. That's why the judge was pushing back. Parents responsible, hard to prove. And some of you guys aren't going to hear that, but that's the reality. Issue is the lawyer is having to issue this lawyer is having is that there's no law saying you have to speak, you don't have to self-incriminate. That's what's really this is about. Petitos have to prove that the Laundrie's intentionally withheld information regarding Gabby's Gabby causing emotional distress, which makes this so difficult. Arlie, thank you for your comments. One more. He's citing precedent from other cases, the judge, in an effort to allow the Petitos family case to proceed. So he did. He tried to combat that, Steph, with their own, but I echo your concerns, and we'll see what happens here. But anything else to add? We'll go to you, Linda. I know you watched the full thing from the other side. Where did they mention the Johnny Depp clip? Does anyone know how I can find that in here?
I did list it in the notes, but there's no timestamp.
What did they say?
The judge was the one that actually brought it up, saying pretty much that when the statement was made by Johnny's lawyer, which I believe was Waldman, how that affected the trial and the outcome and result and verdict. So pretty much they were saying Johnny, it seems like it's looked at, he was held responsible for something that lawyer had said. So they're trying to bring that into this case to say, like, the statement was made by this lawyer. Now, was it told to him to make the statement by the Laundries, or was it just him speaking on behalf of them or himself? So he did mention that about the Johnny case, saying, look, this was brought up and this was a situation that was in this case, and this was just recently for the world to see. So they were trying to just bring that up, that look, we don't know if they had told him to make that statement or not. So pretty much that's the only thing they brought up with the Johnny Depp case.
Interesting. I'm trying
because of what Bertolino said. Even though it came from Bertolino, he's representing the Laundries, so it was effectively the Laundries that said it through Bertolino, just like Adam Waldman said what he said, representing Johnny Depp. So what Adam Waldman said, Johnny Depp really said it through Adam Waldman kind of thing. Is that what you mean, Linda?
Yeah. So that's what it's hard to put in words because we don't know for sure. The Laundries haven't spoken. We just know that one time that they supposedly spoke out was through that lawyer.
Aren't we responsible for the words we say when we say them?
I would agree with that, Your Honor. Certainly, if you say words.
I mean, Johnny Depp just got found civilly liable for defamation by what is.
Oh, I called it.
There it is. So yes, that is what it's about. And now that's an important thing that happened. And Johnny Depp, that one thing that they threw at him, right? The one thing, well, his lawyer said it. Johnny got it was defamatory. So in this case, that really could make a big difference in this. So it'll be interesting to see how that connects. And there we go. Was there any other thing you noticed, Linda, from the Laundrie side that surprised you, or anything else for your notes?
Well, first off, I'm not surprised that they did not appear. They were also reportedly not in the Zoom that was being used in the court for certain people to be involved, like certain media and whatnot. But Steve and Bertolino supposedly was. But I did notice that they were really trying to key in on, just like we saw with Johnny's case, amendments, like the First Amendment, Fifth Amendment. They were both mentioned multiple times. But the main thing is the statement. A lot of questions revolving around the statement where they're trying to say, you know, how much did he know from the Laundries going into saying that statement? And they were pretty much saying, like, the statement came after they received a phone call from Brian. So, and then eventually we knew he showed up without them. So this whole thing, it's wild that it's revolving really about the statement. So that's what's really going to start if this is going to go to trial or not.
Yeah, we'll see. I'm with. I don't think it's gonna. But I hope I'm wrong. But judging by some of the comments I heard when I was watching In and Out, the judge was pushing back a lot. I do think if it goes to a jury trial, there is a little bit more of an emotional heft to this, where I wonder if it's going to be hard for a jury to not see how the Laundries reacted and give it to them. I do think there's a potential path to justice for this family if it can get through this judge. And I don't know, real quick around the table, Kim, do you think it's going to get through?
I don't know. I feel like if it doesn't get through, this is going to be a case that is going to spark a change in laws. Because for me, I look at this and I go, they withheld information that not only affected police at a state level, but it affected it at a federal level. The amount of resources that were wasted during this time frame that had impacts on other cases at that time. This is bigger than just being about a domestic violence dispute. This affected the entire country. And that's kind of my point. I understand that you don't, you're not incriminating yourself, but at the same time, when does it become conspiracy? When does it become obstruction? And that's where I get frustrated, that it's like, I understand that they're limited on how they can fight this, but I don't think it should be limited. And maybe this is going to be one of those cases that it changes the way that we look at these things.
Yeah, fascinating. Steph?
I hate to say it, and I hope I'm wrong, it's not going to go to trial. I just got this sinking instinct feeling, especially what they were saying at the end and the questions that we were getting from Judge. It's just all pointing to it ain't going to go to trial. And Kim, I'm sorry, but I have to disagree. If it don't go to trial, it ain't sparking any change in law. No way, no how. Because if it doesn't, if this lawsuit does not go ahead, it's because of the amendments, and they're not going to override that. No way, no how. Not in America. It's just going to be taken, and that's it. It'll just end, and then that's it. And then the only thing that the Petitos then have to hold on to is the Gabby Petito Foundation and the legacy that Gabby Petito has, to carry on with that. Be on their guard and have that kind of notion in their head that they might not get the justice for Gabby that they want and that they deserve, quite clearly. But I don't think it's going to happen.
Well, I'll try to stay positive here. It's going to be it's an uphill road. But they said the same thing for Johnny. He was able to pull through, and I am pulling for the Petitos. I'm rooting for them tremendously, as we've covered this in great depth, and will continue to if need be. I still have plenty to do. Some once the foundation is official, which you guys should look up, the Gabby Petito Foundation. Another excuse to go do that. If anybody's sort of forgotten about the case, remind yourself, and in honor of Gabby, go over to there. I think you can still get the bracelets and things, or just donate to the family, because it's so sad what happened. So unnecessary. And Brian Laundrie was just the worst. And then that whole case just was a mess. And I really blame the parents, because it really did turn into a circus. We were buried bunkers and theories, and every bald guy. Like, it was. I remember the months. It was. We all fell in a trap of just like all this nothing. Everyone's looking for nothing, because the parents, the Laundries, knew all along that not only was Gabby dead in the beginning, but also they knew Brian was too. Because speculation, I got to be careful, but it really just felt like they knew exactly where that body was. And I still don't believe the sister, Cassie. I think there was a lot of shady stuff that went down, and I think the Northport police, sorry, I'm going to call them out, I think they bumbled it, and I think they just were like, oh, great, it's over? Okay, yes, we did a great job, everybody move on to the next case and stop looking into us, because I do think there was a lot that was gone wrong. Now, do I believe Brian escaped and it's not his bones? No, that's insane. Sorry, not going to go that far. But do I believe there was some corruption and cover up? Yes, I do. And how it all went down, because there was a lot of egg on a lot of face. The fact that I've learned other stuff since then. I just didn't get to report on it. But the water levels weren't as bad as everyone's telling you. There was a lot of stuff that was miscommunicated in this case, and it's just a tragedy what happened. So, look, I'm worried. I share your concern, Steph. I'm gonna do a positive. I'm gonna hope this judge does it, and if this judge puts it through, I do think a jury's gonna have a hard time, even if it's legally specific, right? Just like Johnny's case. Legally, Johnny should have probably lost that case from just a straight legal definition. Like, he probably could have. And the jury heard the evidence, was like, this woman's despicable. I don't believe it, and it's not okay. And I think a similar thing could happen here if they're able to get through and just get the trial, in which case, let's let the jury decide if the Laundries are responsible or not just one person. So I hope that's what happens. Yeah, Steph.
I kind of see where you're coming from there, but in this case, it's slightly different because there was an abundance of evidence, right, at the Johnny Depp trial, that, you know, clearly,
they are not sharing the evidence, Steph.
It was all, hang on though, it was all backed up for Johnny. Also, as well, you had the other side, i.e. Amber Heard, who was always speaking out in the public domain, this, that, and the other. The question here is, what evidence do the Petitos have against the Laundries that could push this through to a trial?
Let's find out, shall we?
The thing
that's what
is,
it's about, Steph.
But hang on a minute. They've just done their arguments,
no,
right?
No, they did not share the evidence.
No, for why it should go to trial. But even though they didn't share evidence, there was nothing compelling enough as to why it should go to trial.
Steph, if they go compelling and give what they got, they don't get to do a case, because then Laundries get to prepare it. That's not how trials work. You don't give away your evidence right away. It's like the whole Michael Jackson thing of civil after thing. Like, to give up your evidence right now would be foolish. Yeah, I understand you got to be compelling, but this is about can they be pursued? This isn't about the evidence right now. And so I think, I completely disagree. Fair to agree to disagree. You don't want to drop your big things right now, because you got to save that for the case, for the jury. And you don't want Laundries to have more time to prepare, because I've heard there is evidence. I've heard there is more stuff in how calculated the Laundries were and how much they knew. And to me, that's what it's about. And it's like, I want to know that. And also, like, think about this. Let's get them on the stand finally, because is it really pleading the fifth if there's no crime? Like, did you know? Like, there's a lot of stuff that I think they're going to be able to ask legally that I would love. And I think that's really what the parents want, to put them on the stand and force them to answer some questions and stop saying, we don't know. We never knew. BS. I mean, that's all I want. And even if they didn't win that case, if they could at least get that in some way, we should get a lawyer on, and we will if this proceeds. And I don't know. I'm speaking out of my butt a little bit, but I mean, that's my dream version of this, right? It's like, get them on the stand and let's finally hear them talk, because I think, Steph, as you said, I think they're going to be another Amber. Like, the lack of emotion from those two, from this fiance that lived with them, who was their stepchild in a way. It's despicable the way they went about this. And I understand, like, their son did something wrong, and we talked about it a lot, right? In this, we're almost revisiting this whole case. We talked about a lot about, like, what do you do if your child does something like that? We had long conversations on those streams, and I was like, I don't know, but at the end of the day, and this case really reiterated, like, I'd have to say something, because that's not going to help my kid to teach them they can get away with it. There are consequences for our actions, and the Laundries didn't feel that. But then I'm also like, if we really go down the conspiracy theory, did the Laundries have anything to do with Brian's? We had Jennifer Coffindaffer, FBI agent here, who was saying the whole thing was weird. So my whole thing is, like, if they got the evidence, you don't want to drop that now. I mean, now, granted, if they lose the appeal, then you're right, Steph, they should have dropped something to get it. But it's a fine dance you got to walk, right? Of, like, say, holding and going. So I don't know. It's a fair fight from Steph, and I like when we have her back.
No, you've changed my mind.
Oh,
okay,
good. I like
enough.
when I do
that. I've come over the fence now. Fair play. I think what I was trying to say, though, is that if you said that there is evidence. Okay, I didn't know that. Fair enough. But I
hear there is.
Not for them to drop the evidence and show all their cards there and then. I would have just expected their argument to be a bit more stronger. I kind of felt that, unfortunately, the Laundrie side was much stronger than the Petitio side, and it's just, I don't know, but no. The way you've explained it now, yeah, fair play. You've changed my mind.
Yeah, I mean, look,
But
we'll
like-
see, and I could be wrong. Maybe they can't get them on the stand, and maybe their evidence sucks. I don't know, but I've heard things, and I'm waiting to, as this progresses, to get more back into this, because this is the big update. If they lose the appeal, it's pretty much a done deal. Now they may then still try to like release some evidence or do some more interviews that are more damning when they've resorted, lost all legal options. In which case, maybe we learn more about the truth about what happened, but. The thing I want to hear, and correct me if I'm wrong, chat and panel, the thing I've been dying for is to finally put some pressure on the Laundries to have to answer the question, why didn't you say anything? And if I got that on a stand, I want to hear that, and I'm sure that's what they want to hear. And to the Laundries who are probably watching, enough is enough. Give this family something. Jesus, it's so sad what you put them through. And I know you went through it too. I do believe it's a tragedy they suffered too. But your son was responsible. It's harder for them. It's way harder for them, and you owe them, and enough is enough. And they could have probably settled this privately maybe if they had just called in the beginning and said, listen, I don't know what to say, but, we can't do, we want to protect our son, but something went wrong. Like
they're definitely putting on pressure, because it seems like the arguments were mainly focused around not just the statement, but the fact of, did he evade a crime? Because they're trying to say about the was there a warrant, and was he a person of interest, and they had a search, was he just under a missing person at the time? So I think a lot of these like tiny details can make all the difference. Like you said, are they going to go by the book? Are they going to go by definition of things, or is this going to be a turning situation in case for different future laws or situations? Like Kim said, we really don't know. It's just, it's hard to even explain, because we all are thinking like, he did it, so the family definitely knew. And we got to think about the timing. And when he was put for search, it was under a missing person, I believe. So it wasn't exactly that he was a person of interest of a murder at the time. So the whole situation of, did they help him evade a crime, is what I think they were trying to put pressure on in this hearing.
Right, I want to address something I see in the comments, because again, if we can look at this objectively, and it's hard sometimes, but now with some time, I'm able to do it. I'm a little less emotional, and I've seen some commenters say they don't owe him anything, and technically, they're right. Like, that's what's complicated about this case. Like, the Laundries don't owe them anything. Like, the Laundries are going through their own suffering. That's what we've heard from them, and that can be, callous and awful, and I find that awful, to be honest, but that's not illegal, is what's the problem with this case, right? That doesn't make me, I don't have to like them, and I don't, but should they go to jail for it? I don't know. And that's why I think this case is so fascinating. Now, this is a civil case. This isn't a criminal case. So for those of you asking, I just wanted to address that. But I do find this case also just fascinating to see where it nets out, because, we all lived this for so many months last year that I do want to see what's right. But yeah, morally, it's awful. I'll never forgive the Laundries, nor I don't think a lot of people will. They buried themselves. They helped themselves. Never did, and their silence, and remember putting the poles and get off the lawn, and removing the Gabby tributes off the lawn. I mean, my God, I'm replaying some of the moments, and if you guys want to go back and want a case to go follow, you can follow our videos of but it's also just sort of weird to go back, because a lot of it was a waste of time, because that family that we were reporting on and wondering where Gabby, what happened to Gabby and where's Brian, they knew all along what happened. They knew all along, in my opinion, what happened. And I will say, I from what I've heard from some things, which I don't want to overstep, because I don't even know if I'm supposed to know. I feel confident in saying the Laundries knew. I feel very confident in saying the Laundries knew, is how I'll say that. Any other comments from the gang here? Kim?
I just kind of feel like, this is always just my own personal opinion and way of thinking, is that if you've done nothing wrong, why not just tell the truth? And I think that's where there's an issue here, is the deafening silence of the Laundries through this whole process.
Yep.
And considering if they did know what they took away from their state, what they took away from their country, the wild goose chase, how they embarrassed all of these law enforcement services, I think it's high time they get on the stand and they answer and they tell the truth under oath. And regardless of whether or not that ends up in charges or a guilty or whatever verdict, I don't really care. I think it's time we just all get the facts on the table. Enough is enough. That's the least that they can give this family.
Well said. Yeah, I agree. I'm going to clip it here just so we have the summary of where things are. We will keep you updated in 2 weeks when we get the verdict, either in a standalone or in our live. So stay tuned. Make sure if you haven't already, hit the subscribe button, hit the bell for all alerts, smash that like button, and leave a comment down below as you watch. What do you think? Are you feeling hopeful or not? I want to hear your thoughts in the comments. Also, make sure you subscribe to It's Kim over on YouTube, Steph the Alter Nerd, and Linda will put her link tree in the comments as well to go support my friends as we start pivoting to other news. Oh God, please guys, let's do this. Enough of Miss Turd. We can talk about other things too. I'm excited. Well, there you go. What a show. We had so much fun, including Amy Goodhart showing up and so much more. We got some insight you're not going to miss. So if you missed the full replay and it's shorter than it seems, hit that join button. You can always catch the replays of our full live streams over on the members only playlist on the main channel page. Pick a tier, become a member, and join. If not that, at least hit that subscribe. Make sure you're subscribed with the bell alerted to all. Smash the like button and leave a comment down below. And make sure you support both my amazing guests that are still here, Amy Goodhart over on Instagram. You can find her there, as well as Steph the Alter Nerd, as well as the Pascal Show, who came by. That was amazing. And It's Kim over on YouTube. Such a good show. I appreciate you guys. We'll be back tomorrow. Jussie Smollett interview. Oh, I'm going to react to that, I think, and so much more. Excited for that. Have a great night, everybody. Bye.